it's about forensic psychology and determining if people are good or bad or are ugly. How good they did. Oh, Mr. Tall Guy's going to change the class. Good. I like that. I'd have to get up on the chair and climb up on the back and whatnot. Anyway, thank you. So the insanity defense is most often used in cases in which the defendant is charged with a violent felony. Majority of defendants found not guilty by reason of insanity have been diagnosed as psychotic. Every time people talk about these mass killings, they say, well, he was insane. The reality is that they're not insane, because insanity is a legal defense, and it has nothing to do with psychology. Insanity is an old idea. Now we talk about mental illness, we talk about psychopathology. They're probably psychopathic. Obviously, they're sociopathic. But these individuals, as far as the legal system is concerned, they're considered insane. Rogers in 1986 estimated that about 1 in 4 or 5 defendants being assessed for insanity engages in at least moderate malingering of mental disorders. So the reality is that unless they really have a mental illness, a provable mental illness, if they try for the insanity defense, about 25%, 20 to 25% are playing, they're pretending that they have a problem. They're malingering. They really don't have a mental illness. Defendants found not guilty by reason of insanity typically have a record of prior arrests or convictions, although this rate does not exceed that of other felons. It's not like they are kleptomaniacs. If you've ever been around somebody that has a compulsion for stealing, it's really kind of interesting. A lot of times they have whatever they need, and that they only steal because they get a rush out of it. I had a friend in college, his father was a lawyer, they were millionaires. The kid, there's no reason that this kid had to steal things, but he did. He would go to the stores. He liked the smaller stores like Dollar General and places like that. They didn't have those stores back then, but they had small, they were, he'd go to Kmart and places like that. Walmart didn't exist back then, but he'd go to these places and he'd steal cheap stuff for no reason whatsoever. And then he'd give it away. I mean, it's not like he stole it. He's like Robin Hood, I guess. Rob from the store and give to the poor, I guess. He would give things, and he would try, sometimes he would try to steal expensive things, and he would give them to his roommate or give them to his fraternity brothers or whatever. His father always made up the difference. His father would, if he discovered that he stole something, he would send an anonymous check to the store. As stupid as that sounds. Anyway, he was a kleptomaniac. When I was stationed in Germany, we had a shortstop, really good shortstop. It's not that he was a staff sergeant. He had enough money, just like everybody else did. But he had this thing about stealing things. And one time we were traveling to Holland for a softball game, and we stopped at it's on the Autobahn. They have these areas where you can buy gasoline, and then there's a store. He went in there and he put on a pair of sunglasses and walked out with them. And he got in the car, and the guy started to chase us. And he said, come on, let's go, hurry up. And we took off, and nobody realized what was going on until we looked back, and the guy was shaking his fist at us. It's one of those kind of deals. And at that point, we realized he had stolen the sunglasses, and we asked him why, and he said he didn't know, of course. I was a psychologist at this time, so I was querying him as to why he stole the sunglasses, why he felt the need to steal the sunglasses. He said he didn't know, but it made him feel good when he stole something, he got away with it. This time he didn't get away with it because everybody knew. He didn't want me to tell everybody else that he had this problem. Anyway, okay, so he was a kleptomaniac. They come from lower socioeconomic backgrounds, usually because of their mental health problems. They have a prior history of psychiatric hospitalizations. Those are the ones that are successful. They have previously been found to be incompetent to stand trial, and for that reason, it's not difficult for them to get a second not guilty by reason of insanity conviction. Female defendants found not guilty by reason of insanity have similar socioeconomic, psychiatric, and criminal backgrounds to their male not guilty by reason of insanity counterparts. So whether it's a male or whether it's a female, it's the same game. They look the same, as curious as that is. I guess that's why I had that picture. They look the same. Melton et al. In 2007 reported the following three beliefs to be prevalent among the public. A large number of criminal defendants use the insanity defense. If you ask people, they think that it happens all the time. Those defendants found not guilty by reason of insanity are released back into society shortly after their NGRI acquittals. In other words, the popular opinion is that not only does this happen all the time, but these people are released as soon as the trial is over with. Persons found insane are extremely dangerous because, you know, insane people do things like, wait a minute, they do things like lick knives. Okay. And they look crazy, and they eat people. I don't know what she does. She's got really sharp teeth. I don't know. This is what we think of people who are determined to be insane.
I was watching Russia's toughest prisons over the weekend.
Oh, really?
And one of their high, person that they had, whatever, he was a cannibal.
A cannibal?
Yeah, so like, they said that he went over to his neighbors and killed them because he annoyed them. And I guess he was explaining himself, like he's like, I was kind of curious to see what they taste like. So he dismembered them and he cut a big old chunk out of their leg and he fried it up. And he ate it, so he didn't like it. So
he didn't like it?
So he tried something out, so I think it was his arm or something. And he said, he also sent like a big chunk of the leg meat to one of his friends who told him it was kangaroo meat.
Kangaroo meat.
And they ate it. They said they made a stew out of it, not knowing what it really was.
Oh, that sounds like fun. Only in Russia. How often is the plea used and how often is it successful? Although the public estimated that insanity defense was used in 37% of the cases, the actual rate was only 0.9%. So they missed it by a lot, by quite a bit as a matter of fact, about 37 times too high. Of the 9 insanity pleas raised in every 1,000 criminal felony cases, about 2 will be successful. So even though it's 0.9%, it's 0.2% that actually are successful. The median number of insanity acquittals per year per state is 17.7. California has the highest number per year at 134, while Florida is second with 111. Any idea why Florida and California are so high? Why would there be more insane people in California and in Florida? What is it about Florida and California that would make people who were insane go there? Arizona has a high level as well. So does New Mexico. So why not New York? Why not Illinois? Why not Iowa? Iowa. So the way my grandson says it. He lives in Iowa. So what's wrong with California and Florida? There must be something wrong with California and Florida. And Arizona. Not so many in Colorado. What's the difference? They have large homeless populations. Large homeless populations of people that were kicked out of mental hospitals. It's warm there. You don't want to move to Montana if you're homeless. It's cold. It's really, really cold, and it's really hard to get warm. But if you move to Southern California, it never freezes in Southern California.
Man, I used to be sad seeing those people on the streets in Missoula in the wintertime.
Oh God, it's so fucking, I'm sorry, it's so cold.
It is.
It is really cold. Just ask Aaron about how cold it is up on the Flathead. Yeah,
I think the lowest it got while we were there was like probably -13 or something.
yeah.
But still, it is freaking cold.
Yeah, that's so cold that if you have exposed skin, that it will freeze in 2 or 3 minutes. Yeah, it's really, really, really cold. Okay, so most homeless people want to go someplace where they can survive. Florida, it very rarely gets below freezing. Southern California, of course, is the same way. New Mexico averages 0, while South Dakota averages 0.1 per year. The reason New Mexico averages 0 is because they don't allow people to plead insane, or it's always unsuccessful. Most acquittals are for felonies. Of course, if they were misdemeanors, then nobody would plead anything. What happens to defendants who are found not guilty by reason of insanity? Many mistakenly assume that defendants who are found guilty who are found not guilty by reason of insanity go free. Stedman and Braff in 1983 found that defendants found not guilty by reason of insanity in New York had an average hospital stay of 3 years, longer for those who had committed more serious or violent offenses. What happens to defendants who are found not guilty by reason of insanity? Some states use a procedure known as conditional release, in which persons found not guilty by reason of insanity are released to the community following a period of hospital confinement and are monitored and supervised by mental health personnel. So these people are never alone. They're always being monitored. As weird as that is, and I don't remember why I put Andrea Yates' picture up. She is still in the hospital. They have moved her. She was in Vernon, and now she is at a lower security hospital somewhere in Texas. And I don't remember where, but she was in Vernon before, which is a high security mental hospital. How dangerous are defendants found not guilty by reason of insanity? Because most who are found in GRI are committed to an institution after their acquittal. It is difficult to assess the risk they pose to public safety. And of course, then they get treatment, and theoretically, they only release them when they are no longer a danger to society. The limited evidence suggests either no difference in recidivism rates between NGRI defendants and regular felons, or slightly lower recidivism rates among the NGRI group. And I guess this is logical, since these individuals have been in treatment. Other individuals who go to jail, normally there is no treatment. So their recidivism rate is relatively high, but for NGRI groups, those individuals have had treatment. And so theoretically, they, of course, if the treatment works, they should have lower recidivism rates. It sends criminals and troublemakers to hospitals, and then it frees them. Researchers' response to this statement: remember that some persons found not guilty by reason of insanity are confined more frequently and for longer periods than defendants convicted of similar crimes. So that is just not true, even though the public thinks that's the way the world works. It is a defense only for the rich. Researchers' response to this statement: There is no evidence of a socioeconomic or racial bias in the use of the success of the insanity defense. As a matter of fact, if somebody were rich and they pled insanity, and there was a case of the guy that shot and killed the wrestler, I can't think of what his name is. He was deemed not guilty by reason of insanity. They made a movie about it. He had a wrestling camp, and he allowed wrestlers to come and train there. And he evidently fell in love with one guy, and he rejected him. So he went up to his house and shot him and killed him. He was deemed not guilty by reason of insanity. Most people with lots and lots of money, these individuals, just like Donald Trump keeps claiming that he's brilliant. What else does he say? He's a stable genius. That's right. He's a stable genius. Yeah, most very wealthy people like to be thought of as smart rather than dumb. If you're a dumb person, then why would somebody invest in your organization? So this isn't really that common for rich people to claim not guilty or take the insanity plea. Note that the Supreme Court case of Ake versus Oklahoma in 1985 ruled that poor defendants who plead insanity are entitled to psychiatric assistance at state expense in pursuing this defense. Something happened yesterday. Oklahoma released 527 prisoners yesterday. Most of them were on drug charges. The reason they released them is because their prison system is packed beyond capacity. They have more females in jail than any other state. 26,000 inmates in the state of Oklahoma. It's not that large a state to have 26,000 Oklahomans in jail. But they released 527 yesterday. And the reason is because it's one of the toughest states to commit a crime in. They have a large law enforcement force in Oklahoma, and when you are convicted, they throw you in jail for a while. They don't mess around. They don't put you on parole. They don't put you on probation. They leave you in jail for an extended length of time. So this is kind of a problem in the state. Now they've released the 527 women. Most of them were women that they released. But they have a larger percentage of women in jail than any other state. As weird as that is. It relies too much on psychiatric experts. That's another problem with the insanity defense. Can clinicians reliably and validly assess mental illness, mental deficiency, and neuropsychological disorders? And the researchers' answer is yes, they can. Will this assessment permit the formulation of accurate opinions about a defendant's criminal responsibility for past acts? Researchers' response: one remedy, prevent experts from giving ultimate opinion testimony. In other words, in some states, they demand that the expert either say he's insane or he's not insane. And what they're saying is they shouldn't have to say definite yes or definite no. A lot of people have problems. Does that make them insane? No, they just have a problem. Sometimes they're okay. Usually they're okay. Sometimes they have a problem. That's usually what a psychiatrist or a psychologist will say. Nobody is always crazy. It just doesn't work that way. So what they're stating is that they shouldn't have to give ultimate opinion testimony. Although the absence of information has not been shown to affect verdicts, the reality is that if they have to be ultimate opinion testimony, forces them to either say yay or nay. And it's easy to find a psychologist that will say nay, because if you're a Rogerian, you think that everybody is lucid for a period of time, in which case you'd say nay, of course. You would always say nay for just about everybody. The guilty but mentally ill, Verdict, about 1/4 of the states allow juries to reach a verdict of guilty but mentally ill in insanity cases. There's a reason why I have a picture of this lady. She was a gun moll for a gangster, and she carried his weapons for him. And she had this strange obsession for this individual. So when they caught him and they caught her, they tried her as well, but they released, or they actually convicted her of being guilty, but mentally ill, because she had this really strange obsession with not only with him, but also with weapons. So she carried weapons. She carried a lot of weapons around, like, I don't know, some kind of superhero. She had guns all over the place. She was really kind of an interesting person. And I don't know why people make that fish face. I don't understand what that's all about. I haven't figured that out yet. I'm sure it has something to do with pornography, but I haven't figured it out yet. I need to look at more pornography. That's what I need to do. Okay. But the fish face is very confusing. The guilty but mentally ill verdict, typically a judge will sentence a defendant found guilty but mentally ill exactly as one found guilty of the same offense. In some jurisdictions, guilty but mentally ill convicted individuals would start his or her term in a hospital and then be transferred to prison after treatment is completed. In others, the individual would receive treatment while serving a prison sentence. Note that sometimes overcrowding in hospitals means that defendants go to prison without treatment. He didn't like the way their leg tasted. That is so fascinating. I wonder what it tasted like. Oh, I told you what human flesh tastes like. Yes, it does. Several states allow a defense of diminished capacity. It applies to defendants who lack the ability to commit a crime purposely and knowingly, and that has to do with diminished capacity. Now you have to understand which state you're dealing with, of course, as to whether they allow diminished capacity defense. Diminished capacity differs from insanity in that it focuses on whether the defendants have the state of mind to act with purpose and intent to commit a crime, but not on whether they knew the crime was wrong or whether they could control their behavior. Usually this is an elderly individual or somebody with a intellectual deficit. These individuals are more likely to get a diminished capacity defense. Elimination of the insanity plea. Of course, this happened after the Reagan assassination attempt. The conservatives were really upset. Ronald Reagan was fairly popular, just like Donald Trump is. Donald Trump is really popular with conservatives and Republicans. They love him. I'm not exactly sure they're going to have the same. There's going to be the same reaction after his presidency is over that happened with Reagan. I mean, they named this and that and the other after Ronald Reagan. He's got an airport in, where does he have an airport? I think it's in Washington, D.C. Ronald Reagan Airport? Yeah, I think it's in Washington, D.C. Anyway, yeah, he's got his own airport, you know, that kind of stuff. Roy Rogers Airport is in Anaheim, California. Anyway.
Doesn't he have a library in California too?
Ronald Reagan Library. Yeah, it's as a matter of fact, it's one of the wildfires.
Yeah.
Is about to burn the place down. I think they saved it though. I'm pretty sure they saved it. Conservatives loved him. Liberals didn't like him very much. They claim that he saved the economy, but if you understand how the economy works, I'm not sure he saved anything except lots of money for the wealthy people. So let's not go there. Anyway, so when he was almost assassinated in 1980, whatever, 81, I think, the conservatives just went berserk, especially after the individual Hinckley pled the insanity, had used the insanity defense, and he was successful. They wanted to do away with the insanity plea completely. So all this has to do with politics. I know it's so stupid. Come on, this is the legal system. Why are we reacting? Why are we making this knee-jerk reaction to one thing that happened? I mean, we didn't have a knee-jerk reaction to the man blasting away at the concert in Las Vegas, where 417 people were wounded and 57 were killed. I mean, we didn't have a knee-jerk reaction to that, but Ronald Reagan gets hit by a ricochet, and everybody goes insane.
Did you hear about that bombing or whatever that NBC had in Alamo?
Oh, yeah.
Yeah, there was a bomb apparently that went off in one of these teepees.
Okay.
It was during our coyote sermon.
Yeah,
Was somebody hurt?
Yeah.
2 people were killed.
Oh my
14 people
goodness.
were hurt.
And they poisoned the morning and night water that people drink. And those are the 2 that died.
Huh. And that was when?
Saturday, I think.
Saturday.
Saturday.
In Cuba.
Is that right? And I haven't heard anything about this. Why would I? It's not on CNN. And I watch Albuquerque News, so
Should have been out there.
I don't
It
know.
was on the KOB website.
Okay. How interesting. That is fascinating. Well, I guess we'll have a knee-jerk reaction to see what happens. And the answer is probably nothing. We've been talking, I talked to not Dr. Barber, but Mr. Barber, Professor Barber. I talked to Professor Barber from time to time. He's involved in MMDR. Yeah, right. MMIW, murdered and missing women. What we have determined is that they need more law enforcement on the reservation. There's just nobody, I mean, there's no cops around. There's just never, I never see them. I drive way too fast, so nobody ever stops me. And people pass me, so.
And I always see, there's this group that I follow, the road conditions on the Navajo reservation. They're always posting about like car crashes and accidents happening all over the res.
There's a lot of animals wandering around. Somebody's going to die one of these days. Marius hit a horse in his truck. Took him 2 months to get his truck fixed. Never was right. He still has it, but killed the horse. But there were 3 dead horses over by, where was it? Oh, in between Window Rock and Gallup. There were 3 dead horses, one right in a row. It's like a semi took them all out or something. But they were all just stacked up right there.
It kind of seems like there's actually no laws for that, like nobody's held accountable. So it seems because it's still happening, it's still happening a lot.
Well, you have open range.
I mean, not the animals, more like the accidents, like vehicles or like stuff like that.
Well,
The animals I understand because like, I don't know, there's a whole debate that's been going on with that for like quite some time now.
Right.
And like how they're supposed to identify who the owners are and all these other stuff because a lot of these animals are actually unmarked, so they're just.
Oh, really? So
Not
nobody knows who they.
not-
who
Not
they
all of
belong
them, but I'm just saying there's a majority of them that are like unmarked, so it's just like, how do you, who's held accountable for those ones?
to. Well, they had all those horses that died over on the other side of Tuba, right? The 200, they got stuck in the mud.
Oh, yeah.
Oh, ugly, last year, or the year before, I can't remember. Okay, so we've decided they need more law enforcement, that's what we've decided. And we've also come up with a plan to create a task force to investigate all these cases. That should be interesting. The problem is you get families involved. The families have this emotional attachment to the select individual, And they have an agenda. They want the person to either be murdered or they want them to have been trafficked. They want something, and it's not always the case. Sometimes they're runaways, sometimes it's abuse, family abuse, and so they've disappeared. They just need somebody with a realistic point of view, which would be the criminal justice system, to determine that. And so we try to come up with, the clock's not working, is it? No. You broke it. Good job. Well, and the reality is there are 5 states that have abolished the insanity defense, but it's almost impossible to even discuss crimes without discussing the person's state of mind when they committed the crime. Battery's dead. Yeah. The U.S. Supreme Court in Atkins versus Oklahoma in 1982 held that a trial court must consider any potentially mitigating information, for example, evidence that argues against a death sentence when considering a sentence of death. Some jurisdictions also consider the question of a defendant's future risk to society, and of course, that is one of the reasons why we put people in jail, is to protect society from them. Clinical evaluations must also address the question of eligibility for capital sentencing if the defendant may be intellectually disabled, which would exempt defendants from the death penalty, consistent with Supreme Court decision in Atkins versus Virginia in 2002. Virginia wanted to execute Atkins, who had committed a crime, but Atkins was intellectually disabled. He had a fairly extreme intellectual deficit, and because of that, they wouldn't allow. The Supreme Court decided that they couldn't execute him. During the 1980s and 1990s, there was reform in the juvenile and criminal justice system in the United States to allow more frequent prosecution of juveniles in criminal adult court. Some of the states really went to town on this. The state of Indiana went berserk over the idea of a juvenile, if they commit a crime, then they need to be tried as a serious crime, then they need to be tried as an adult. This was fairly controversial. I told you about my cousin who murdered a guy. Then he fled to another state where they didn't extradite back to Indiana. The idiot decided that he would come back to visit his girlfriend after he turned 18. Of course, now he's an adult. They arrested him for murder, and then they put him in jail for life. He got out after about 25 years. They paroled him. Those evaluating juveniles for the possible transfer must focus on the risk of future offending, the interventions needed to reduce the risk, and the likelihood that the youth will respond favorably to such interventions. I hope you don't think that I'm saying that he shouldn't have been tried. He should have been tried as an adult. He did the deed. He committed the crime. He knew what he was doing, and he should have been punished. He was an idiot. And when I say idiot, I'm not saying he had an intellectual deficit. What I'm saying is he had a compulsion and to kill this guy, and they went ahead and did it. It was dumb, and he shouldn't have done it. He actually has a fairly high IQ, not that that's important, but he deserved to be put in prison. My cousin. Despite the fact that he's family, he needed to be in prison. It really did cool him down a lot. He was kind of a goofy kid before. Kind of a wild kid. He thought he could get away with anything because he was so smart. Okay. Sometimes intelligence gives you the idea that you can do anything. And if that's the case, then yeah, you need to go to jail. That's okay. I'd rather be dumb and not a criminal than smart and a criminal. Evaluating a youth being considered for transfer is a forensic evaluation. States vary in their specification of the age at which an adolescent is eligible for prosecution in the criminal system. Most still use the age of 14 or 15. If they're below the age of 14 or 15, you cannot try them as an adult. There are several justifications for transfer into the criminal system. If they are charged with homicide, there was the 14-year-old that I told you about who stopped to help the lady change her tire, then he raped and murdered and mutilated her, and he threw her baby into the river, and of course the baby drowned. That individual was tried as an adult. He was convicted and he was sentenced to death. They waited until he was old enough to execute, and then they executed him, is what happened. The Pope was against it. The Pope came out against executing a criminal, a child for a capital crime. But it didn't make any difference. They executed him anyway. Charged with other specific violent felonies such as sexual assault. There was an individual in Montana, 16-year-old boy. He, for some reason, he'd been looking at the wrong pornography, and he decided that what he wanted to do was he wanted to have sex with a dead woman. So he was driving down this is in Great Falls, Montana. He was driving down the street one day. He saw this lady jogging, and he had seen her every day. She jogged along the same route. So he decided he was going to kill her and rape her, or he was going to have sex with her dead body, which is known as necrophilia. Anyway, he ran over her. He swerved off the road, knocked her down, ran over her, picked her up and threw her in the back of his truck. As it turned out, she wasn't dead. He was only 16. He was going to school, by the way. He was going to school. So he went to school in his pickup truck with this dead lady in the back of his truck. She, of course, regained consciousness and crawled out of the back of his truck, went to the police, of course, and then he got arrested. It was a huge deal. It was just before I left. It was like 2010. Anyway, they weren't exactly sure what they were going to charge him with. You know, reckless driving, attempted homicide, procuring a body for a cadaver for sexual purposes. They weren't exactly sure what they're going to charge him with, or whether they were going to charge him as an adult or a minor. Eventually, they charged him as an adult. The problem was that he was like the captain of the football team, and he was, you know, the top student at the school. That was the bizarre part. So they weren't exactly sure what they wanted to do with this kid. But eventually, of course, they tried him as an adult and they convicted him, and I guess he's in jail for a while. He didn't kill her. As a matter of fact, he just knocked her out. And he hit her pretty hard, but he just kind of knocked her over, and then he didn't run over her with his wheels. You know, he kind of cleared her. It's Montana where they have jacked up trucks just like you guys have. Anyway, he didn't hit her with anything else. Juveniles can be transferred to criminal court in different ways. The state legislature can determine that certain offenses must be filed directly in adult court, and this is known as statutory exclusion. So if you commit the wrong crime in a select state, then you will be tried as an adult whether you're a juvenile or not. The juvenile court can decide whether the youth should be transferred to criminal court, and this is known as judicial discretion. Prosecutors can decide whether cases are to be filed initially in juvenile or adult courts, and this is known as prosecutorial discretion. Is putting juveniles in the adult system effective in reducing reoffending? A question that comes up constantly. There has been no decline in juvenile crime after these transfer laws came into effect. So does it work or does it not work? Well, no, doesn't change anything. Housing juveniles with adult criminals may promote criminal attitudes and motivations. Higher rates of recidivism have been observed when youth are transferred into the adult system. Juveniles in adult facilities are more likely to be sexually and physically assaulted than youths in juvenile facilities. So it's kind of dangerous for the kid. I don't even have a clue what time it is. Juvenile transfer may also occur in the other direction. Juvenile placed in adult court or returned to juvenile court. This happens from time to time. This procedure has been called reverse transfer, where the individual starts out in the adult criminal justice system, and then they're transferred back into the juvenile system. 25 states currently have reverse transfer procedures that allow juveniles in adult court to petition for transfer back to juvenile court. And that is it for chapter 10. Let's go ahead and start chapter 11. Kind of fun chapter. But then again, I find all these chapters fun. There we go. Okay, we're going to start chapter 11. Forensic assessment in civil cases. We were talking about forensic assessment in criminal cases. Now we're going to talk about civil cases. Mental health experts can be involved in hearings and trials in many civil areas, including the following: psychological damages to civil plaintiffs, workers' compensation claims, the assessment of civil competence, psychological autopsy, which is always fun, child custody and parental fitness, civil commitment and risk assessment. Psychological autopsy has to do with taking a look at the mental health history of someone who has died to determine if they actually had a mental illness. That's what a psychological autopsy is all about. An expert can testify if the testimony is relevant, the usefulness of the testimony outweighs whatever prejudicial impact it might have, and if the judge believes that the testimony is based on sufficiently relevant and reliable scientific evidence. For example, Dalbert-Kumho criteria, which I'm not exactly sure what it is. Testimony must be found on solid science. There's a lot of goofy scientists out there who have theories. Sometimes they're conspiracy theories. A lot of this science is not universally held. One of the huge controversies right now is whether global warming is real or whether it's not. There are select scientists, not very many of them, that state that global warming is not real, that it isn't caused by humans. As a matter of fact, today we are removing ourselves from the Paris Accords, which dictates that we have to control our waste products from the United States, mostly carbon dioxide waste in the air. It seems that the people that believe in global warming think that we are producing too much carbon dioxide. Too much, our carbon footprint is too great. This is one of the reasons why they closed the coal power plant over at Black Mesa. It was the largest coal burning plant in the United States. And they just recently closed last year, I think. Anyway, the reason they did it is because it's such a mess. It creates such a horrible mess. The problem is the coal that you have around here has a lot of sulfur in it. When you burn the coal, the sulfur gets up into the air, it mixes with other minerals in the air, and it creates a acid rain. It creates sulfuric acid. I know, isn't that fun? Okay, so they decided that they would close the plant because of all the contamination that was being closed. Last weekend in India, they had to close the airport because of the smog. can't think of where it was. Bombay, what used to be Bombay? Mumbai. It was Mumbai. Anyway. Yes. Okay, so we have good science and we have bad science. There is a conflict as to whether evolution is real or it's not real. There is one state that where you cannot teach evolution. If you teach evolution and one of your students complains, then you can be fired, thrown out of the state for teaching evolution. Evolution, of course, is fairly universal. A lot of people accept it, but not in the state of Kansas. So be careful where you talk about evolution. You can talk about it everywhere except in Wichita or Kansas City. Or Salina. So if you decide to go to Haskell, to college, or University of Kansas or Kansas State, don't talk about evolution. Judges often have trouble evaluating scientific evidence, thus the concern that jurors will be exposed to junk science. And for that reason, I mean, there are scientists, you can find a scientist that disagrees with another scientist, no matter how universal that piece of evidence is. The federal government, the Trump administration does not support global warming, the concept of global warming. They claim that it's not being caused by, and that's why they pulled out of the Paris Accords, because they don't like the strictures that science puts on on businesses, on manufacturing. Smith in 1989 cites the following potential objections to testimony by psychological or psychiatric experts. The scientific foundation for much of the testimony offered in court is often less than adequate. Much of the testimony is of limited relevance. A lot of the problem is that jurors aren't sophisticated enough to understand the science. That's okay. A lot of times the judges aren't sophisticated enough to understand the science. A lot of times the lawyers don't have a clue about the science. Sometimes I'll be watching a prosecutor making a statement and I'm going, you know, I was in medicine for 30 years and that's not even close to being right. I mean, they're getting all the words wrong and mispronouncing the words, and they're not getting the concepts correct. I do have a background in medicine, so I do have some understanding of medicine, and they're not getting anywhere close. Much of the testimony is of limited relevance. A lot of times when you're talking about a specific scientific idea, it goes off into the ionosphere and it doesn't have anything to do with a specific case. Experts are too often permitted to testify about ultimate issues which should be left to juries to decide. In other words, they're making determinations where they shouldn't be making determinations. Experts' testimony is frequently used to introduce information that would otherwise be prohibited because it is hearsay. Sometimes when we won't go into that. The adversarial system compromises experts' objectivity. Expert testimony is very expensive, and relying on experts gives an advantage to the side with more money. And of course, this is a problem as well. Testing the reliability and validity of expert opinions through cross-examination is inadequate because attorneys are usually not well equipped to do this, and juries often fail to understand what is uncovered during the cross-examination. So the reality is that no one is sophisticated enough in that courtroom to understand what they're really talking about, except for the experts themselves. So if you have two experts, they probably understand what the other one is saying. But the juries are rarely that sophisticated or that educated to understand what's going on. Normally, if you have an educated juror, they will remove them. The lawyers don't want them in the court because then the juror can argue against the lawyer. The lawyer only has a smattering of understanding of what's going on, and he wants, or she wants, they want their opinion to be the one that is accepted. And if you have an educated juror, a lot of times that juror will be more sophisticated than the lawyers themselves, and so they don't want them in the courtroom. They don't want them to be jurors. Experts disagreeing with one another in trial after trial ultimately reduces the public's esteem for mental health professionals, and of course this is an interesting problem. I told you about the cognitive psychologists, and this isn't the only cognitive psychologist that I've talked to that didn't believe in mental illness. He didn't even want to look at the DSM-5. He considered the American Psychiatric Association a hoax. And they put out this book, and he didn't even care what it said. Of course, the rest of the mental health community, that has become our Bible, I guess, small b Bible, I guess. But that select individual didn't believe in mental illness. He just thought it was a misunderstanding or a misinterpretation of events. That's what caused mental illness, or that's what we call mental illness. Grisso's 2003 criticisms of forensic mental health assessment. The reality is, if you put any three psychologists in a room, well, at least one of them is going to agree with the other two. That's just the way it works. Professor Barber and I, when we talk about things, very often we agree on things. But as soon as he finishes his PhD, I'm sure that we will get into more arguments. Dr. Kind and I used to get into some interesting discussions about pieces of psychology, whether they worked or not. One of them is whether subliminal messages actually work or whether they don't. That was kind of interesting. Now I figured out why she thinks that subliminal messages don't work. There was a psychologist at Lethbridge, which is up in Canada. She's Canadian. Okay. Anyway, there was a psychologist up in Lethbridge that in 1989 proved that subliminal messages didn't work because he put together this piece of research. I looked at the research and I'm thinking, that's not enough people. And he's using college students. I mean, why in the world would we assume that college students are average? Anyway, that was the piece of research that she was referring to. Before 1989, no one had really argued about it, but this one psychologist. Well, anyway, it's not important. I know, here we are, psychologists arguing with one another. As much fun as that is. Anyway, so Sarah and I got into a screaming match. No, not really. We just disagreed with one another. Ignorance, not knowing or not using the proper legal standards. Grisso's criticism of forensic mental health assessment. There's a problem with ignorance, not knowing or not using the proper legal standards. Irrelevance, providing evidence that goes beyond what is relevant to the proceedings. Intrusion, offering conclusions that impinge upon the court's domain. Insufficiency, providing limited supporting evidence for one's conclusions. Incredibility, offering conclusions that are not justified by the evidence one provides. And of course, when you're hired to look at these things, a lot of times you see what you're supposed to see. What they tell you, they think you should see, unfortunately. To reduce the overly adversarial nature of expert testimony, some have proposed to limit the number of experts on a given topic, require that the experts be chosen from an approved panel, allow testimony only from experts who have been appointed by a judge. If you've ever watched these movies or these television shows, they're always going to Washington State for an expert, or maybe Florida or New York, and they're always going way away from where the case is being heard to find an expert that will agree with their testimony. that will give them the right testimony, as sad as that seems. Okay. Several reforms of expert testimony have been proposed. Courts should not allow clinical opinion testimony unless it can be shown that it satisfies standards of scientific reliability. Ban any reference to witnesses as experts. Instead, use opinion testimony or witnesses. Read a special instruction to juries before any opinion testimony in order to reduce its possible prejudicial impact. Juries are just like students. When students read their syllabus, they see what they want to see. So if you have a due date, and as a matter of fact, your papers were due today, your papers are due today. A lot of students, around Thanksgiving, they'll send you an email and say, well, I read the syllabus and I didn't see that due date in there. Okay, well, you see what you want to see. Of course you see what you want to see. I sent you guys an email telling you that just turn in your paper when you get it done. That I accept late work. I'm not like select individuals who demand that things be done on their schedule. So just get it in, that's okay. But students are really good at misreading things. I had an individual who was keeping up with all of his assignments, and then he skipped the midterm. He just didn't take the midterm. This is in my 240 class. So he emailed me one day and said, I didn't realize there was a midterm. Where is it? You know, it's right there, right under. You've been reading doing all of your assignments, and it's the next one. But so he had selective reading ability, selected what he wanted to see. Anyway, a lot of jurors are the same way. And that has to do with opinion. When one party is injured by the action of a second party, the injured individual can sue the second party to recover monetary damages as compensation for the injury. This action is covered by an area of civil law known as torts. If you talk to people who have been to law school, torts class was probably the hardest class for anybody because each state has their own tort laws. And tort laws have to do with damages, tort laws have to do with injury, and determining whether someone was injured and what damages should be awarded is very difficult. So tort class is one of the hardest types of law to practice. A tort is a wrongful act that causes harm to an individual. I told you my son he teaches down in Florida, and one day he found an individual sleeping on the campus. He tapped him on the bottom of his foot to wake him up, and the kid went ballistic, claimed that he assaulted him when he kicked him on the tapped him on the bottom of his foot. His parents came, they were going to sue my son for damages. They claimed that he had an injury to his shin. I'm not sure how it happened. They claimed that he actually kicked him in the shin. Well, luckily there was a security camera that actually picked the whole thing up. And so they watched the security. They called the police. So here my son is in the office. The police are there ready to arrest him for assault. And they watched the film, and the principal said, I don't think that's what happened. And then the policeman looked at the film and he said, that's not what, he didn't kick him in the shin, he tapped him on the foot. And of course, the parents are screaming, or the mother, actually it was just the mother, was screaming that he had damaged her delicate child. You know how delicate children are. Anyway, the policeman started laughing. The principal said, you know, I didn't want to call you in, but the parents demanded it. So my son was exonerated, of course. And they tried to take it to court. And they tried to get the film, the security footage thrown out so that they couldn't use it as evidence. As stupid as that sounds. Anyway, it never went to court. 4 elements are involved in proving a tort in a court of law. If it can be established that there was a duty that was breached, which approximately caused the harm resulting, then a tort can be proven in a civil lawsuit. A case that I know about that just happened recently around here, an individual was being transported it wasn't an ambulance, it was it was one of those medical transportation services. Anyway, they had, it was an individual in a nursing home, and they transferred her, they transported her to the hospital. And when they transported her to the hospital, the mechanism that holds the wheelchair, that allows the wheelchair to be slowly lowered, one side collapsed, and the wheelchair pitched over, and it dropped the lady on her head. And she had this huge bruise on the side of her head, and she died about a week later. So the question is, can they sue the company? That's the question. They want to sue the company. Now the bizarre part was that this lady, the reason they were transporting her to the hospital was because she was near death. They wanted to find out how much longer she had to live. They dropped her on her head, and she only lived another week. So the question is, how long would she have lived if they had dropped her on her head, is the real question. That's not really the question. The real question is, should they pay damages for faulty equipment? That's really what the case is going to be. Yeah, it's going to get ugly, because this lady was dying anyway. Well, that's not a very nice thing to say, but she was dying. So they had a duty, they had equipment, and the equipment failed, which caused the lady to fall on her head, and it resulted in a bruise on the side of her head. Now the question is, did that kill her or not? And she had diabetes. She was starting to reject dialysis. Yeah. So that's going to be an interesting case if it ever goes to court. Or they'll probably settle out of court, but the organization will probably have to fold rather than pay damages. Historically, the law sought to compensate victims who are physically hurt or sustained property losses, but was reluctant to allow compensation for emotional distress. This is known as pain and suffering. So the question is, how much is pain and suffering worth? This has changed in recent years, of course. Now 2 types of psychological injuries are claimed in civil lawsuits. Those arising from negligent behavior, those arising from extreme and outrageous conduct that is intended to cause distress. Interestingly, the Paddock, is that the guy's name that shut up Las Vegas? He had a lawsuit against one of the casinos where he slipped and fell, and he was trying to sue the casino for, I don't know, $1 million or something. That's really the only legal deposition that we have of this individual. I mean, he's fairly mysterious. They rarely have pictures of him. He wasn't on any of the Facebook pages. Nobody knew anything about him. But they did have this deposition that he filed saying that he slipped and fell on the floor in a casino, and he tried to sue them for it. Now the interesting thing was he was in flip-flops at the time, and they were old flip-flops, and they broke. So the question was, did they break and cause him to fall, or was it the fact that there was a problem with the floor? That was the question. And of course, the damage was minimal. And it was a case similar to this. There was water on the floor, The water had, it had rained in Las Vegas, which doesn't happen very often. And no one had mopped it up yet. And he stepped right in it for one reason or another, and he fell, or he said he fell. So it was a case of negligence. In recent years, an increased number of cases have dealt with the psychological injuries resulting from the tort of sexual harassment, usually in the workplace. Plaintiffs can seek both compensatory damages, payment for injuries suffered, and punitive damages, punishing the company for its failure to respond properly to misconduct. This has been a really serious problem with actors and actresses and news agencies. Fox News has recently been sued, and the movie's coming out in December, by some of their blonde, all of the female news people at Fox are blonde. It is the oddest thing in the world. Gretchen Carlson, Megyn Kelly, there's any number of other blonde. It's like blonde. They have to be blonde in order to be on television. Maybe it's easier to like somebody who's that pale in complexion. Anyway, it turned out that Roger Ailes, who started Fox News, was the individual that was sexually harassing them. And of course, if it had gone to court, they would have had to pay for injuries. They would have also been punished, probably. But it's been settled out of court, I believe, so it's never actually going to go to court. Harvey Weinstein is today, his trial starts today. His rape trial starts today. Now, he claimed that he never did anything, that any sex he had with any select individual was consensual sex, that they did it because they wanted to advance their careers, which is kind of interesting. Anyway, I guess he tried to seduce Gwyneth Paltrow, and instead she left the movie that he was producing. As curious as that is. A clinician assessing a plaintiff will typically conduct an evaluation that includes a social history, a clinical interview, psychological testing, third-party interviews, and a review of available records. So they'll look at everything, and it takes a while. The clinician forms an opinion about the person's psychological condition. The clinician determines whether the psychological problems were caused by, were aggravated by, or existed before the tort. In other words, before the individual damaged them. So if somebody charged, wait a minute, what are we doing? We're talking about sexual damages, aren't we? There was a case when I was in the military. An individual claimed that there was too much smoking taking place in her work area. To the extent that she started wearing a gas mask because she was very sensitive to tobacco smoke. This is back in the 70s when a lot of people smoked and there weren't any places where you couldn't smoke. I worked in the laboratory and we had a chain smoker in the laboratory. And he constantly had a cigarette in his mouth, which was okay because we used him as positive control for carbon monoxide poisoning. Since when you smoke tobacco, when you smoke cigarettes, the burning of the paper creates carbon monoxide, which they're constantly pulling down into their lungs. So this individual would actually turn out positive for carbon monoxide poisoning. So we used him as our positive control. We used me as our negative control because I was a runner and I had really healthy lungs. Anyway, what was I talking about? Oh, anyway, so this lady sued the United States Air Force for a hostile working environment because she kept asking people not to smoke around her, and of course, military people being the jackasses that they sometimes are, they would light up and they'd go over to her desk and pretend to have a conversation with her or need to have something done, so they would blow smoke in her face and stupid things like that. So she sued them. It was a tort case, and guess what happened? She won. Her lungs really were hypersensitive to tobacco. Anyway, so the military stopped allowing people to smoke in buildings after that case. There were several other cases that were very similar to that. Anyway, she won her case, and the Air Force lost. Plaintiffs may be motivated to exaggerate their claims in order to improve their chances of winning larger awards. Sometimes such symptom exaggeration or fabrication, normally called malingering, involves outright lying. The individual pretends that they had more damage done than actually was done. In other cases, a real psychological disturbance is present, but the plaintiff exaggerates its seriousness. So instead of being depressed, they claim to have bipolar disorder, and of course, in order for them to win their case, they have to have extreme symptoms of bipolar disorder. So they have to lie. They have to malinger, as it were. One more slide. When a worker is injured in the course of his or her job, the law provides for the worker to be compensated through a streamlined system that avoids the necessity of proving a tort. This system, available in all 50 states in the federal government, is known as workers' compensation law. Workers' compensation law is a really, really good idea, because sometimes businesses, especially now that we're loosening all the laws to allow more manufacturing and more profit, sometimes workers are injured. Sometimes they do dangerous jobs that are very difficult, and they deserve to be compensated. Why don't we stop right here? We'll pick this up with workers' compensation